Okay, good morning, and welcome to NEXCO's online training. My name is Jerry Crisantello, and I serve as the Executive Director of NEXCO. NEXCO is a nonprofit business association that provides training and educational events via seminars and webinars for the international trade community. Today's webinar will cover ITAR compliance, and we are fortunate to have Alan Szynski, who is president of ITD Associates. He has had over 30 years of experience working directly with the ITAR regulations, and in fact, he was directly involved in writing the current version of ITAR during his tenure with the State Department. I will turn this meeting over to Alan.
Registration requirements. Every U.S. company that's involved in any way with defense trade has to be registered with the State Department. There are thousands of U.S. companies registered with the state. Now, if you manufacture defense articles, you have to register. Even if you never export, you may be a component supplier to the Lockheed, the Boeings, and whatever, and they configure your equipment into their aircraft, missiles, and they apply for export licenses. You still have to be registered with the State Department. They want to know about everybody involved in any way with defense trade, and that's how they do that, by causing them to register. You export, clearly you have to be registered, and the third requirement is that if you're involved with brokering sales of defense articles, you have to be registered with the State Department as well. The registration fee was always a flat fee until basically the last year and a half. Companies that never exported pay the exact same fee that a company like Boeing that exports under hundreds and hundreds of licenses a year. They pay the exact same fee. Now, after all these years, the registration fee is based on how many licenses a company processed the previous year. So the Boeings are paying literally many thousands of dollars for the privilege of exporting, as opposed to that company that never exports and will pay the base fee, minimum fee. When companies register, they're required to identify the individual or individuals who are basically overseeing their export program, the so-called empowered officials. These are the individuals basically designated by company management to not only oversee the program, but sign license requests. They have authority to sign license applications to the State Department. And they're the only individuals in the company with that authority. And the State Department knows who they are because companies are required to identify them to the State Department as part of the registration process, and notify the State Department if those individuals change the empowered officials. And so it's obviously a very responsible position to be in, because when you sign a license application to the State Department, you are basically, as the empowered official, certifying that the information you're presenting is complete and accurate. So companies have to be very, very careful these days as to who they empower. The best way to understand this process is to really get a firm handle on some basic definitions. There are not a lot of them, but they're really, really critical. And again, this is where a lot of the confusion arises, because again, there's a lot of interpretation here. And again, ask questions, because I don't know, I don't want to read about you in the New York Times or whatever. What's the defense article subject to these controls? Yes, it's on the munitions list. And by the way, the munitions list is part 121 of the ITAR. And if you look at part 121, when we do the exercise later on, I've got a few copies of the ITAR that you can take a look at. But if you look at the munitions list, if you're not that familiar with it, you'll see that it is also broadly, generally written and subject to interpretation. What does it say for Category 8 military aircraft? Category 8A is complete military aircraft, period. It doesn't tell you that certain aircraft have been removed from the list over the years, old aircraft that the U.S. military hasn't used maybe in many, many years. Another subcategory is aircraft engines. Another major subcategory is parts, components, accessories, and whatever for military aircraft. Well, in a military aircraft, it's conceivable that there could be commercial components in the aircraft. Who has jurisdiction over those? Is it now the State Department, or is it still the Commerce Department because they're commercial items? So all these things have to be sorted out, and basically your defense article meets these criteria right here, that they are specifically designed, developed, configured, modified for military application, or have significant intelligence applicability. The key word in the definition of what constitutes a defense article is specific. Something is a defense article if it was specifically designed for military use. The criteria basically is heavily weighted to the origins of the item. That's the primary thing that the State Department looks at when they make a determination as to whether or not something falls under these requirements. Is a defense article. What are its origins? What was the intent in developing it? Consequently, you have items that were developed, say, under a Department of Defense contract. No question they're defense articles. You have items that have military nomenclature. Those are defense articles. You have, this is where it gets very, very tricky at times. You have articles that when they were being developed, the intent was that they will meet certain military specifications. And what's a real problem there is you can go down the street here, find a Radio Shack or whatever, and buy some electronics gear and test it, and you may find it meets a mil spec. Coincidentally, does that mean it's subject to these controls or not? The fact that something coincidentally meets a mil spec when you test it does not mean it's a defense article. It gets back to the basic question of intent in developing it. Attempting to develop something that will meet mil specs, mil standards, is different from basically that something coincidentally does if you test it. That's a very fine distinction and causes a lot of problems in determining who has jurisdiction over certain items, Commerce or State Department. But that's the basic consideration right there. Now, what further confuses the equation is you can have something that basically by that definition qualifies as a defense article. But over years, it's determined that it's being more and more used in commercial programs rather than military programs. And there may be a point where it becomes predominantly used in civil programs. That will be a very good potential argument for removal of that item from the munitions list. And the second consideration is if a company can make a very good case that form, fit, function-wise, performance equivalency-wise, an article equates more to items used commercially rather than in military programs, that's another good potential argument for removing something from the munitions list. But if something is on the list, by that definition, it can only be removed through a formal process called the commodity jurisdiction process. You basically...
I'm sorry, before we move on, a question. Say you have a washer, and it's just a washer. Mm-hmm. It's sold commercially, but Northrop Grumman or one of those guys calls you and says, we want your washer, but we want it a little bit bigger.
Okay.
Not tempered, not... but it's bigger to fit in our jet aircraft.
Right.
The company's not exporting, they're sending it to Seattle, Washington, or wherever they're sending it to. I mean, how is that covered by the State Department? Or is it?
Yeah, technically, you've modified a commercial item for a defense purpose. So technically, you've militarized it. Now, if it becomes, when you enlarge it, basically just a larger commercial washer that's, again, used in all sorts of commercial applications, you're not going to have a problem with State Department by and large on that.
But if you're only selling it to defense contractors, then
Right.
you just change the size,
Right.
even though it's...
Technically, the State Department face these sorts of things all the time, from that sort of situation to taking we had a company many years ago out in California that was building strictly commercial radios. All the componentry and whatever was commercial, but they wanted to see if they could sell it to military organizations, so they made it look military, painted olive green and unattractive, whatever, and all of their sales promotion literature, showed the troops dragging that radio through the mud and whatever. So they were selling it to military organizations, but it absolutely was a commercial radio. And in fact, we verified it was because I personally processed a commodity jurisdiction case that they submitted to get a formal ruling on who had jurisdiction. And the verdict was Commerce Department.
And what about if you just paint something?
If you just paint something?
Like camouflage, because
No.
they want it for... They want camouflage for military purpose. They want it black because it doesn't reflect the light or...
Well, that's where painting it a different color is not going to be a problem. Painting it with some special purpose paint or whatever that in and of itself is on the munitions list can be a problem then. Because there are certain paints that are on they're on the list. So if you paint it with those paints, you basically militarize it.
But just like a regular black mat?
No. And interesting that radio company, one day I got a frantic call from them. What happened? We were trying to export some equipment to, I don't remember what foreign military organization, and Customs, and with no State Department license, and Customs stopped the shipment. And they said, this is a military radio, it certainly looks like one, and you're sending it to a military organization, we're seizing the shipment and whatever. So they called me, what do we do? I said, find that old letter that we sent to you that says it's not on the munitions list and show it to Customs. They did, no problem. But these are the sorts of things that companies have to be concerned with.